Brooklyn, is that right?
Yes.
Okay. So I'm in my little studio apartment on the west side of Manhattan. It's nice to see you all. My day job is I'm an in-house attorney for Peloton bike company. But when I was back in high school in Indiana, I did the We the People program. So I'm an alum. I kind of know what it's like to be in your seat, though I never made it to nationals and I never did it virtually. So thank you very much for all of your preparation and for being here, and looking forward to the discussion today.
Good morning, New York. Congratulations as well. My name's Andy Levy. I'm a trial lawyer from Baltimore, and I teach at both of Maryland's 2 law schools. And I'm in a little town called Highland, which is about halfway between Baltimore and Washington, D.C.
Good morning. I'm Chuck Dunlap. I'm Executive Director of the Indiana Bar Foundation, and I'm in Indianapolis this morning. So very good to see you. And I'm also an adjunct professor at Indiana University. I'm looking forward to talking with you more this morning.
Would you please introduce yourselves and your teacher?
Good morning. My name is Mitchell Lev.
Good morning. My name is Ivas Hasanov.
Good morning. My name is Radion Debija.
Good morning. My name is Gregory Dancy II.
And today we are also joined by our 3 coaches, Ms. Rudder, Ms. Kovet, and Ms. Azoff, our principal, Ms. Cohen, and our state coordinator from the Justice Research Center, Ms. Deborah Lesser.
Wonderful. Thank you all for your support in getting the students prepped in here. Okay, so you know the drill. I'm going to read through the question in its entirety, and that'll cue you all to begin your prepared remarks and start the clock, okay? Richard Posner wrote that the American public worries more about invasions of privacy than about summary proceedings against suspected terrorists, curtailments of the freedom of speech of the law-abiding, or the right of the media to publish government secrets. Do you agree or disagree with this statement? Why or why not? To what extent, if any, is privacy in jeopardy today? And what protection, if any, do people have from privacy violations by governments or businesses? You may begin.
They who can give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety. This doctrine of American government, as enshrined by Benjamin Franklin, has been the touchstone of the most sacred American ideals: life, liberty, and the pursuit of happiness. These ideals trace to the shield of the American people in one guiding principle: privacy. In the words of Justice Brandeis, the right to be left alone is the most comprehensive of rights and the right most valued by civilized men.
While the Constitution has no express protection for the right of privacy, the Founding Fathers sought to protect its individual aspects. The Supreme Court has recognized an implied right of privacy in the First, Third, Fourth, Fifth, Ninth, and 14th Amendments. These rights have been continuously recognized by the judiciary, constructing a penumbra of protections in the balance of government interests against constitutional privileges.
In Griswold versus Connecticut, the Supreme Court ruled against the prohibition of contraceptives, as marital relations are offered special protections which the government cannot interfere with. Similarly, a Texas statute banning sodomy was struck down in Lawrence versus Texas, since it intentionally interfered with the private acts between consenting adults. In Stanley versus Georgia, Thurgood Marshall wrote, "Whatever may be the justification for other statutes regulating obscenity, we do not think they reach into the privacy of one's home." In Roe v. Wade, the Supreme Court guaranteed a woman's right to abortion under a substantive due process clause securing the privacy of choice. While each ruling pertains to distinct aspects of privacy, the evident motif in American jurisprudential history encompasses a principle of limited government interference with liberty and the private affairs of the people.
The Fourth Amendment frames the Constitution's most explicit protection of privacy, precluding the government from conducting unreasonable searches and seizures. In the landmark case of Cass v. United States, the court adopted the standard of a reasonable expectation of privacy. This standard is reflected even with the advancements in technology. In Kyle v. United States, the Supreme Court ruled against the use of heat detection technology against an individual's home. Justice Scalia reasoned that considering the technology was not available to the public, citizens have a reasonable expectation of privacy in their own homes. However, the court ruled in Florida v. Riley and Greenwood v. United States, respectively, that there is no reasonable expectation of privacy from helicopter surveillance over one's home or in garbage placed on the curb.
Yet privacy concerns permeate modern society. An expansive Patriot Act permitted the government to enter citizens' homes virtually. And in 2013, Edward Snowden exposed the American government for their spying, revealing a spiderweb of surveillance networks constructed by the National Security Agency. Concerns in the private sector include the collection of data from private entities such as Facebook. In the 2016 election period, the personal information of up to 87 million Facebook users ended up in the hands of a voter profiling company. Other modern-day privacy concerns entailed the government's extended tracking of cell phone location data and the possible reversal of Roe v. Wade and the right to abortion.
While Posner accentuates issues of curtailment of freedom of speech, summary proceedings against terrorists, and the right of media to publish government secrets, these concerns become obsolete without the protection of privacy, abridging the encroaching tendencies of an inevitably tyrannical state. In New York Times v. United States, the Supreme Court ruled against prior restraint, and in Texas v. Johnson, the court protected privacy of thought, allowing the citizens to burn the American flag as a form of protest.
Privacy is one of the most imperative protections offered by the Constitution. Anthony Burgess once said, "To be left alone is the most precious thing one can ask of the modern world." This protection has been extended by the United States from sea to shining sea with a singular ideology. Liberty prevails.
Great, thank you very much. Would you please put any notes away and we will move to the follow-up questions. Okay, I would like to kind of start by circling back to the Cambridge Analytica scandal that you mentioned and ask this panel, do we have a right to our personal data? And what happens when we give that right to a company like Facebook? What sort of protection should we expect? Go ahead.
Certainly we have a right to that data, and I think one of the biggest controversies of that case is that many of Facebook's users weren't willingly giving it up. I think that if we look at that scandal in particular, it's important to note that that information, while it was acquired by a private entity such as Facebook, it was even used by government officials and government entities which abridged our Fourth Amendment, our privacy rights offered by the Constitution.
As a Facebook user, you can also make your posts private, as you can make them public, private, or only to friends. So if you make your posts public, everybody can see them, while unless you make them private, it's more entitled to you only.
So I think that case had to do with Facebook kind of taking your data in the background and not necessarily about your posts. So maybe like your browsing behavior, what news stories you focused in on, and was selling that to companies who ultimately used it to interfere with our election, or that was the allegation. Should the government have access to that data?
Well, I think we look at some of the essential protections that the founding fathers put into the Constitution. It was to protect us from a government going into our personal information and like using that against us. So I think that the government having access to this data that we don't willingly give up to Facebook most of the time shouldn't be allowed, as we want to protect ourselves from an overreaching government.
But so you mentioned that the right of privacy does not extend to garbage placed on the curb. This is under the fiction that we have no reasonable expectation of privacy in that, which is, if you think about it, an absurd notion. But if that's the law, that our reasonable expectation of privacy doesn't extend to something like that, which contains all sorts of private stuff that we wouldn't want other people knowing, how can you say that there's a reasonable expectation of privacy in any of this other data?
Well, I think if we look at the case that established that standard of Katz versus United States, the conscious act that the Supreme Court referred to in that case was the closing of the phone booth door. So I think when someone is actively surfing Facebook, for example, in the privacy of their own home, they wouldn't expect to be willingly giving up their information at that point in time. And I think that is one of the biggest aspects that the Supreme Court has looked at over and over again, is where the action occurs. And they have offered special protections to acts that occur in the privacy of one's home, such as in Lawrence versus Texas and other cases. So at that moment in time, it is a difficult question for the court to balance whether someone has a reasonable expectation of privacy in that data. But I think when that act isn't, you aren't consciously giving up that data, then at that point, we do have a reasonable expectation of privacy in it.
I agree with my colleague. When we download apps, we give the app certain certain information about us, and we expect the app to keep it private. So therefore, we would not like the government to reach in and collect our personal data or any information that we give to the app. We give them information that we choose, and the government should not be able to access any of that the data that we choose to trust the app with.
So, go ahead.
Oh, and certainly this is a theory that's also been upheld by the Supreme Court. If we look at cases like Carpenter versus United States, the Supreme Court ruled that the government is precluded from entering a person's information on a phone without a warrant. So the Supreme Court has upheld this idea of privacy within our electronics, which is extended both to the direct contents of the phone and the contents on their apps.
So taking that to the current COVID-19 situation, where government, contact tracing and the ability of government to track movements in the name of public safety and public health, how should courts handle that while still trying to protect and preserve some level of individual privacy? What's the balancing that courts should deploy in making those determinations?
Well, I think when we look to the balance of people's privacy and the protecting people against this virus, we have to look that the government interest is to protect the welfare of the people. So we look to them checking people's locations to see whether they're out in the park or on the beach. That can seem somewhat reasonable. We have to make sure they don't go too far. Like if you look at cases like Kylo v. United States, the use of heat detection technology to see people's heat signatures within their own homes was seen as overreaching. So if the government were to look to see people's temperatures were, for instance, over a certain degree within their own homes, that would be overreaching to ensure the public safety.
I agree with my colleague. For example, in New Mexico, they were using cell phone towers to track the movement of people in order to prevent the spread of the virus. I believe that courts should be more involved in how the government reaches into our privacy and into our private data to track us in a way to prevent the virus. I feel the courts should be more involved, and they should separate the government from accessing this data, but in a way coming up with something more useful where more people are aware of the government's awareness in their daily life.
All right.
Perfect timing.
Perfect timing. Very good. Nice job, guys. So we'll go through a bit of feedback. I just take a deep breath. You're done. That was excellent. I thought your prepared remarks, really comprehensive kind of overview of the foundational, case law and what we find in the Constitution. I thought you did a good job giving us the overview. And I like when folks, don't just name drop cases, but actually give us a little context about what the case was about. And you guys did a good job kind of tying that through to help us kind of understand your argument. I would have liked to spend a little bit more time on violations of privacy by businesses. That was part of the question. You certainly touched on it, and that's obviously where I wanted to go in the follow-ups. That's the work I do every day, right? Is how much are individuals giving up? I mean, in theory, we charge our consenting adults in this country with being able to read a contract and understand what they're agreeing to before they enter into it. And so arguably, if Facebook's terms of service say, we're going to share all of your data with the government, and by using this site, you're agreeing to it, that is a contract that's enforceable, at least in the current state of play, right? Other than unless you're looking at other kind of constitutional protection. So I would have loved to dig into that a little bit more with you all, but you did a great job kind of bringing us back to case law in the follow-ups to show us that you really had a mastery of kind of what you presented in the prepared remarks. So great job.
Yeah, great job indeed. I was really impressed by your opening. I like the Ben Franklin quote, which I've heard before, but I don't think I've heard it in answer to this question this year. And I think that was a really sort of interesting springboard into, then it was like a nice survey of the various the leading cases in privacy. And then it really, and then sort of, I thought when we sort of then started asking you questions and, to really try to test whether you really had an understanding or an appreciation of these sources, I thought you really acquitted yourself very well. I mean, it made me believe that that you weren't just, saying names of cases, that you did understand it. I wish we'd had more time. I mean, my goodness, these are complicated questions. You can barely, scratch the surface in the 10 minutes we have. But it really does, your presentation and your answers to the questions really emphasize to me, we have this whole sort of, jurisprudence that was developed at a time when, there was no such thing for the most part. Well, really, there was no such thing as the internet, and phones were attached to the wall. And just the paradigm shift in terms of the different ways of storing and communicating information is it's a genuine paradigm shift, akin to the invention of the printing press. And I think we're just beginning to understand all of the consequences of that. So great job.
Yeah, I agree with my colleagues. I really enjoyed it. And it's interesting to me, and I think your comments and your discussion covered this idea that privacy can talk about reproductive privacy. I mean, it's such a broad area, and the courts have dealt with it as it has progressed and as technology has progressed, which is always a driver of public policy and law and jurisprudence. But the idea, and I think you talked about it, from Griswold to Lawrence v. Texas, privacy can be a lot of different things, and new things are emerging all of the time. And the idea, are the protections set up to handle what we currently have, or do we need new protections? Do we need an amendment to the Constitution that's focused specifically? And you mentioned privacy isn't even specifically enumerated and listed in the Constitution, but it's this whole gathering of different aspects of it. And I thought you had a really good grasp of that knowledge as a basic, important, fundamental aspect of this whole area, and you did a really nice job with that. So thank you very much. I really enjoyed our conversation.
I just want to thank the teachers again, both students and teachers. This is obviously very, very strange circumstances for you to have had to prepare for the national competition, and you guys really brought your A game. So thank you so much.
Here. Absolutely. Great job, guys. Stay safe.
Thank you for your time.
Thank you.